Hey everyone, today we're going to talk about consideration in the context of formation of contracts. Consideration is essentially the idea of reciprocity. I give you something, you give me something. There is an exchange of something of value to each party. The person making the promisor, has to give consideration, and the person receiving the promisee, also has to provide consideration in exchange for the promise from the promisor. Let me give you an example. Let's say a contract for the sale of the car. I promise to sell my car to Peter. Okay, Peter promises to buy the car for $50,000. So my consideration is the car. Peter's consideration is $50,000. There is a mutual exchange of something of value. An act or promise will constitute valid consideration only if requested by the promisor. So using the previous example, I promise to sell my car to Peter for $50,000. The consideration from Peter has to be requested by me. Okay, I am the one requesting for $50,000 for the car. The payment of $50,000 by Peter to me is valid consideration because I was the one who requested for the consideration. Therefore, it's valid consideration. If the consideration was not requested by me and Peter provides some other form of consideration, maybe a motorcycle or something, it is not valid consideration. Conversely, a person who requests another person act to his detriment will be bound by his promise, as detriment is sufficient consideration for a promise. So for example, in the case of Gay Chun Ing, the defendant in that case, at the plaintiff's request, gave up claims for severance pay in the plaintiff's company in return for promise by the plaintiff to give the defendant certain shares. Essentially, the defendant, who is Gay Chun Ing, wanted to resign from the plaintiff's company, and then there were negotiations for his severance packages, including severance pay, and there was some shares held on trust. Okay, so there was a dispute as to who owned the shares, who was beneficially entitled to the shares. So the defendant, Gay Chun Ing, okay, at the plaintiff's request, decided that he would not claim severance pay, okay, in return for the plaintiff's promise to give him the shares, which were held on trust. And then the court found that the detriment in not wanting the severance pay, in foregoing the severance pay, was sufficient consideration in enforcing, the defendant enforcing the promise to give the shares to him. Also, past consideration is not good consideration. So if an act is done before and independently of a promise, then it is not good consideration. So for example, if I offer to paint Peter's house, okay, out of the goodness of my heart, okay, I paint it already out of goodness of my heart, I don't discuss anything about paying me money. After painting the house, Peter says, okay, he wants to pay me $1,000 for painting his house. I cannot later, if Peter does not pay me the $1,000, I cannot sue him later, because the consideration, me painting the house, was past consideration. It was not made at the time of the contract. So past consideration is not good consideration. Next, consideration must move from the promisee, the person who receives the promise. So if I enter into an agreement to paint David's house for $1,000, okay, I promise to paint the house for David. David promises to pay me $1,000 for painting the house. David's consideration of $1,000, David is the promisee, the person receiving the promise. The consideration from David, the $1,000, has to flow from David. It has to come out from his pocket. But there is no requirement for the consideration to move to me. In other words, David, although David has to pay money from his own pocket, it doesn't have to pay to me. I can direct David to pay it to someone else who I owe money to, for example. So David, the $1,000 does not necessarily have to be paid to me. It could be paid to John. Okay? So thanks for watching this video on consideration.